Chapter 2. Administrative Relations General 256. Obligation of states and the Union. The executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state, and the executive power of the Union shall extend to the giving of such directions to a state as may appear to the Government of India to be necessary for that purpose. 257. Control of the Union over states in certain cases. 1. The executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the Union, and the executive power of the Union shall extend to the giving of such directions to a state as may appear to the Government of India to be necessary for that purpose. 2. The executive power of the Union shall also extend to the giving of directions to a state as to the construction and maintenance of means of communication declared in the direction to be of national or military importance, provided that nothing in this clause shall be taken as restricting the power of Parliament to declare highways or waterways to be national highways or national waterways, or the power of the Union with respect to the highways or waterways so declared, or the power of the Union to construct and maintain means of communication as part of its functions with respect to naval, military and air force works. 3. The executive power of the Union shall also extend to the giving of directions to a state as to the measures to be taken for the protection of the railways within the state. 4. Where in carrying out any direction given to a state under Clause 2, as to the construction or maintenance of any means of communication, or under Clause 3, as to the measures to be taken for the protection of any railway, costs have been incurred in excess of those which would have been incurred in the discharge of the normal duties of the state if such direction had not been given, there shall be paid by the Government of India to the state such sum as may be agreed, or, in default of agreement, as may be determined by an arbitrator appointed by the Chief Justice of India, in respect of the extra costs so incurred by the state. 257a. Assistance to states by deployment of armed forces or other forces of the Union Rep. By the Constitution, 44th Amendment, Act, 1978, S. 33, WEF 2061-979. 258. Power of the Union to confer powers, etc., on states in certain cases. 1. Notwithstanding anything in this Constitution, the President may, with the consent of the government of a state, entrust either conditionally or unconditionally to that government or to its officers functions in relation to any matter to which the executive power of the Union extends. 2. A law made by Parliament which applies in any state may, notwithstanding that it relates to a matter with respect to which the legislature of the state has no power to make laws, confer powers and impose duties, or authorize the conferring of powers and the imposition of duties, upon the state or officers and authorities thereof. 3. Where by virtue of this article powers and duties have been conferred or imposed upon a state or officers or authorities thereof, there shall be paid by the Government of India to the state such sum as may be agreed, or, in default of agreement, as may be determined by an arbitrator appointed by the Chief Justice of India, in respect of any extra costs of administration incurred by the state in connection with the exercise of those powers and duties. 258a. Power of the states to entrust functions to the Union. Notwithstanding anything in this Constitution, the governor of a state may, with the consent of the Government of India, entrust either conditionally or unconditionally to that government or to its officers functions in relation to any matter to which the exclusive power of the state extends. 259. Armed forces in states in Part B of the First Schedule Rep. By the Constitution, 7th Amendment, Act, 1956 S. 29 and SCH. 260. Jurisdiction of the Union in relation to territories outside India. The Government of India may, by agreement with the government of any territory not being part of the territory of India, undertake any executive, legislative or judicial functions vested in the government of such territory, but every such agreement shall be subject to, and governed by, any law relating to the exercise of foreign jurisdiction for the time being in force. 261. Public Acts, Records and Judicial Proceedings. 1. Full faith and credit shall be given throughout the territory of India to public acts, records and judicial proceedings of the Union and of every state. 2. The manner in which and the conditions under which the acts, records and proceedings referred to in clause 1 shall be proved and the effect thereof determined shall be as provided by law made by Parliament. 3. Final judgments or orders delivered or passed by civil courts in any part of the territory of India shall be capable of execution anywhere within that territory according to law. Disputes relating to waters. 262. Adjudication of disputes relating to waters of interstate rivers or river valleys. 1. Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution or control of the waters of, or in, any interstate river or river valley. 2. Notwithstanding anything in this Constitution, Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint as is referred to in clause 1. Co-ordination between states. 263. Provisions with respect to an interstate council. If at any time it appears to the President that the public interests would be served by the establishment of a council charged with the duty of 1. Inquiring into and advising upon disputes which may have arisen between states. 2. Investigating and discussing subjects in which some or all of the states, or the Union and one or more of the states, have a common interest. Or 3. Making recommendations upon any such subject and, in particular, recommendations for the better co-ordination of policy and action with respect to that subject. It shall be lawful for the President by order to establish such a council, and to define the nature of the duties to be performed by it and its organization and procedure. Part 12. Finance, Property, Contracts and Suits. Chapter 1. Finance General. 264. Interpretation. In this part, Finance Commission means a Finance Commission constituted under Article 280. 265. Taxes not to be imposed save by authority of law. No tax shall be levied or collected except by authority of law. 266. Consolidated Funds and Public Accounts of India and of the States. 1. Subject to the provisions of Article 267 and to the provisions of this chapter with respect to the assignment of the whole or part of the net proceeds of certain taxes and duties to states, all revenues received by the Government of India, all loans raised by that government by the issue of treasury bills, loans or ways and the means advances, and all monies received by that government in repayment of loans shall form one consolidated fund to be entitled the Consolidated Fund of India, and all revenues received by the government of a state, all loans raised by that government by the issue of treasury bills, loans or ways and the means advances, and all monies received by that government in repayment of loans shall form one consolidated fund to be entitled the Consolidated Fund of the State. 2. All other public monies received by or on behalf of the Government of India or the Government of a State shall be credited to the public account of India or the public account of the State, as the case may be. 3. No monies out of the Consolidated Fund of India or the Consolidated Fund of a State shall be appropriated except in accordance with law and for the purposes and in the manner provided in this Constitution. 267. Contingency Fund. 1. Parliament may by law establish a contingency fund in the nature of an impost to be entitled the Contingency Fund of India, into which shall be paid from time to time such sums as may be determined by such law, and the said fund shall be placed at the disposal of the President to enable advances to be made by him out of such fund for the purposes of meeting unforeseen expenditure pending authorization of such expenditure by Parliament by law under Article 115 or Article 116. 2. The legislature of a state may by law establish a contingency fund in the nature of an impost to be entitled the Contingency Fund of the state, into which shall be paid from time to time such sums as may be determined by such law, and the said fund shall be placed at the disposal of the governor of the state to enable advances to be made by him out of such fund for the purposes of meeting unforeseen expenditure pending authorization of such expenditure by the legislature of the state by law under Article 205 or Article 206. Distribution of revenues between the Union and the states. 268. Duties levied by the Union but collected and appropriated by the states. 1. Such stamp duties as are mentioned in the Union list shall be levied by the Government of India but shall be collected a cents in the case where such duties are leviable within any Union territory, by the Government of India, and a cents in other cases, by the states within which such duties are respectively leviable. 2. The proceeds in any financial year of any such duty leviable within any state shall not form part of the Consolidated Fund of India, but shall be assigned to that state. 1. Omitted by the Constitution, 101st Amendment, Act, 2016, 269. Taxes levied and collected by the Union but assigned to the states. 1. Taxes on the sale or purchase of goods and taxes on the consignment of goods except as provided in Article 269A shall be levied and collected by the Government of India but shall be assigned and shall be deemed to have been assigned to the states on or after the first day of April, 1996 in the manner provided in Clause 2. Explanation. For the purposes of this clause, I sense the expression taxes on the sale or purchase of goods shall mean taxes on sale or purchase of goods other than newspapers, where such sale or purchase takes place in the course of interstate trade or commerce. I sense the expression taxes on the consignment of goods shall mean taxes on the consignment of goods, whether the consignment is to the person making it or to any other person, where such consignment takes place in the course of interstate trade or commerce. 2. The net proceeds in any financial year of any such tax, except in so far as those proceeds represent proceeds attributable to Union territories, shall not form part of the Consolidated Fund of India, but shall be assigned to the states within which that tax is leviable in that year, and shall be distributed among those states in accordance with such principles of distribution as may be formulated by Parliament by law. 3. Parliament may by law formulate principles for determining when a sale or purchase of, or consignment of, goods takes place in the course of interstate trade or commerce. 269A1. Goods and services tax on supplies in the course of interstate trade or commerce shall be levied and collected by the Government of India, and such tax shall be apportioned between the Union and the states in the manner as may be provided by Parliament by law on the recommendations of the Goods and Services Tax Council. Explanation. For the purposes of this clause, supply of goods, or of services, or both in the course of import into the territory of India shall be deemed to be supply of goods, or of services, or both in the course of interstate trade or commerce. 2. The amount apportioned to a state under Clause 1 shall not form part of the Consolidated Fund of India. 3. Where an amount collected as tax levied under Clause 1 has been used for payment of the tax levied by a state under Article 246A, such amount shall not form part of the Consolidated Fund of India. 4. Where an amount collected as tax levied by a state under Article 246A has been used for payment of the tax levied under Clause 1. Such amount shall not form part of the consolidated fund of the state. 5. Parliament may, by law, formulate the principles for determining the place of supply, and when a supply of goods, or of services, or both takes place in the course of interstate trade or commerce. 270. Taxes levied and distributed between the Union and the States. 1. All taxes and duties referred to in the Union list, except the duties and taxes referred to in Articles 268, 269 and 269a, respectively, surcharge on taxes and duties referred to in Article 271 and any cess levied for specific purposes under any law made by Parliament shall be levied and collected by the Government of India and shall be distributed between the Union and the States in the manner provided in Clause 2. 2. The tax collected by the Union under Clause 1 of Article 246A shall also be distributed between the Union and the States in the manner provided in Clause 2. 3. The tax levied and collected by the Union under Clause 2 of Article 246A and Article 269A, which has been used for payment of the tax levied by the Union under Clause 1 of Article 246A, and the amount apportioned to the Union under Clause 1 of Article 269A, shall also be distributed between the Union and the States in the manner provided in Clause 2. 4. Such percentage, as may be prescribed, of the net proceeds of any such tax or duty in any financial year shall not form part of the Consolidated Fund of India, but shall be assigned to the states within which that tax or duty is leviable in that year, and shall be distributed among those states in such manner and from such time as may be prescribed in the manner provided in Clause 3. 5. In this article, prescribed means, a cents until a finance commission has been constituted, prescribed by the President by order, and a cents after a finance commission has been constituted, prescribed by the President by order after considering the recommendations of the Finance Commission. 271. Surcharge on certain duties and taxes for purposes of the Union notwithstanding anything in Articles 269 and 270. Parliament may at any time increase any of the duties or taxes referred to in those articles except the goods and services tax under Article 246A, by a surcharge for purposes of the Union, and the whole proceeds of any such surcharge shall form part of the Consolidated Fund of India. 272. Taxes which are levied and collected by the Union and may be distributed between the Union and the States omitted by the Constitution, 80th Amendment, Act, 2000, S. 4. 273. Grants in lieu of export duty on jute and jute products. 1. There shall be charged on the Consolidated Fund of India in each year as grants in aid of the revenues of the states of Assam, Bihar, Orissa and West Bengal, in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products to those states, such sums as may be prescribed. 2. The sums so prescribed shall continue to be charged on the Consolidated Fund of India so long as any export duty on jute or jute products continues to be levied by the Government of India, or until the expiration of 10 years from the commencement of this Constitution, whichever is earlier. 3. In this article, the expression prescribed has the same meaning as in Article 270. 274. Prior recommendation of President required to bills affecting taxation in which states are interested. 1. No bill or amendment which imposes or varies any tax or duty in which states are interested, or which varies the meaning of the expression agricultural income as defined for the purposes of the enactments relating to Indian income tax, or which affects the principles on which under any of the foregoing provisions of this chapter monies are or may be distributable to states, or which imposes any such surcharge for the purposes of the Union as is mentioned in the foregoing provisions of this chapter, shall be introduced or moved in either House of Parliament except on the recommendation of the President. 2. In this article, the expression tax or duty in which states are interested means a censor tax or duty the whole or part of the net proceeds whereof are assigned to any state, or a censor tax or duty by reference to the net proceeds whereof sums are for the time being payable out of the Consolidated Fund of India to any state. 275. Grants from the Union to certain states. 1. Such sums as Parliament may by law provide shall be charged on the Consolidated Fund of India in each year as grants in aid of the revenues of such states as Parliament may determine to be in need of assistance, and different sums may be fixed for different states. Provided that there shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of a state such capital and recurring sums as may be necessary to enable that state to meet the costs of such schemes of development as may be undertaken by the state with the approval of the Government of India for the purpose of promoting the welfare of the scheduled tribes in that state, or raising the level of administration of the scheduled areas therein to that of the administration of the rest of the areas of that state. Provided further that this shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of the state of Assam sums, capital and recurring, equivalent to I cents the average excess of expenditure over the revenues during the 2 years immediately preceding the commencement of this Constitution in respect of the administration of the tribal areas specified in Part 1 of the table appended to paragraph 20 of the 6th Schedule, and A cents the costs of such schemes of development as may be undertaken by that state with the approval of the Government of India for the purpose of raising the level of administration of the said areas to that of the administration of the rest of the areas of that state. 2. On and from the formation of the autonomous state under Article 244(8), A cents any sums payable under Clause A of the second proviso to Clause 1, shall, if the autonomous state comprises all the tribal areas referred to therein, be paid to the autonomous state, and, if the autonomous state comprises only some of those tribal areas, be apportioned between the state of Assam and the autonomous state as the President may, by order, specify. I cents this shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of the autonomous state sums, capital and recurring, equivalent to the costs of such schemes of development as may be undertaken by the autonomous state with the approval of the Government of India for the purpose of raising the level of administration of that state to that of the administration of the rest of the state of Assam. 3. Until provision is made by Parliament under Clause 1, the powers conferred on Parliament under that clause shall be exercisable by the President by order, and any order made by the President under this clause shall have effect subject to any provision so made by Parliament. Provided that after a Finance Commission has been constituted no order shall be made under this clause by the President except after considering the recommendations of the Finance Commission. 276. Taxes on professions, trades, callings and employments. 1. Notwithstanding anything in Article 246, no law of the legislature of a state relating to taxes for the benefit of the state or of a municipality, district board, local board or other local authority therein in respect of professions, trades, callings or employments shall be invalid on the ground that it relates to a tax on income. 2. The total amount payable in respect of any one person to the state or to any one municipality, district board, local board or other local authority in the state by way of taxes on professions, trades, callings and employments shall not exceed 2,500 rupees per annum. 3. The power of the legislature of a state to make laws as aforesaid with respect to taxes on professions, trades, callings and employments shall not be construed as limiting in any way the power of Parliament to make laws with respect to taxes on income accruing from or arising out of professions, trades, callings and employments. 277. Savings any taxes, duties, cesses or fees which, immediately before the commencement of this Constitution, were being lawfully levied by the government of any state or by any municipality or other local authority or body for the purposes of the state, municipality, district or other local area may, notwithstanding that those taxes, duties, cesses or fees are mentioned in the Union list, continue to be levied and to be applied to the same purposes until provision to the contrary is made by Parliament by law. 278. Agreement with states in Part B of the first schedule with regard to certain financial matters Rep. By the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. 279. Calculation of net proceeds, etc. 1. In the foregoing provisions of this chapter, net proceeds means in relation to any tax or duty the proceeds thereof reduced by the cost of collection, and for the purposes of those provisions the net proceeds of any tax or duty, or of any part of any tax or duty, in or attributable to any area shall be ascertained and certified by the Comptroller and Auditor General of India, whose certificate shall be final. 2. Subject as aforesaid, and to any other express provision of this chapter, a law made by Parliament or an order of the President may, in any case where under this part the proceeds of any duty or tax are, or may be, assigned to any state, provide for the manner in which the proceeds are to be calculated, for the time from or at which and the manner in which any payments are to be made, for the making of adjustments between one financial year and another, and for any other incidental or ancillary matters. 279A1. The President shall, within 60 days from the date of commencement of the Constitution, 101st Amendment, Act, 2016, by order, constitute a council to be called the Goods and Services Tax Council. 2. The Goods and Services Tax Council shall consist of the following members, namely: A. Cents the Union Finance Minister. Chairperson A. Cents the Union Minister of State in charge of Revenue or Finance. Member A. Cents the Minister in charge of Finance or Taxation or any other minister nominated by each state government. Members. 3. The members of the Goods and Services Tax Council referred to in sub-clause C of clause 2 shall, as soon as may be, choose one amongst themselves to be the vice-chairperson of the council for such period as they may decide. 4. The Goods and Services Tax Council shall make recommendations to the Union and the states on A. Cents the taxes, cesses and surcharges levied by the Union, the states and the local bodies which may be subsumed in the goods and services tax. A. Cents the goods and services that may be subjected to, or exempted from the goods and services tax. A. Cents model goods and services tax laws, principles of levy, apportionment of goods and services tax levied on supplies in the course of interstate trade or commerce under Article 269A and the principles that govern the place of supply. A. Cents the threshold limit of turnover below which goods and services may be exempted from goods and services tax. A. Cents the rates including floor rates with bands of goods and services tax. A. Cents any special rate or rates for a specified period, to raise additional resources during any natural calamity or disaster. I. Cents special provision with respect to the states of Arunachal Pradesh, Assam, Jammu and Kashmir, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Himachal Pradesh and Uttarakhand, and A. Cents any other matter relating to the goods and services tax, as the Council may decide. 5. The Goods and Services Tax Council shall recommend the date on which the goods and services tax be levied on petroleum crude, high-speed diesel, motor spirit, commonly known as petrol, natural gas and aviation turbine fuel. 6. while discharging the functions conferred by this article, the Goods and Services Tax Council shall be guided by the need for a harmonized structure of goods and services tax and for the development of a harmonized national market for goods and services. 7. 1/2 of the total number of members of the Goods and Services Tax Council shall constitute the quorum at its meetings. 8. The Goods and Services Tax Council shall determine the procedure in the performance of its functions. 9. Every decision of the Goods and Services Tax Council shall be taken at a meeting, by a majority of not less than 3/4 of the weighted votes of the members present and voting, in accordance with the following principles, namely: I. Since the vote of the central government shall have a weightage of 1/3 of the total votes cast, and I. Since the votes of all the state governments taken together shall have a weightage of 2/3 of the total votes cast, in that meeting. 10. No act or proceedings of the Goods and Services Tax Council shall be invalid merely by reason of a. Since any vacancy in, or any defect in, the constitution of the Council or a. Since any defect in the appointment of a person as a member of the Council or a. Since any procedural irregularity of the Council not affecting the merits of the case. 11. The Goods and Services Tax Council shall establish a mechanism to adjudicate any dispute a. Since between the Government of India and one or more states or a. Since between the Government of India and any state or states on one side and one or more other states on the other side or a. Since between two or more states, arising out of the recommendations of the Council or implementation thereof. 280. Finance Commission 1. The President shall, within 2 years from the commencement of this Constitution and thereafter at the expiration of every 5th year or at such earlier time as the President considers necessary, by order constitute a Finance Commission which shall consist of a chairman and 4 other members to be appointed by the President. 2. Parliament may by law determine the qualifications which shall be requisite for appointment as members of the Commission and the manner in which they shall be selected. 3. It shall be the duty of the Commission to make recommendations to the President as to I. Since the distribution between the Union and the States of the net proceeds of taxes which are to be, or may be, divided between them under this chapter and the allocation between the states of the respective shares of such proceeds. A. Since the principles which should govern the grants in aid of the revenues of the states out of the Consolidated Fund of India. A. Since the measures needed to augment the Consolidated Fund of a state to supplement the resources of the panchayats in the state on the basis of the recommendations made by the Finance Commission of the state. A. Since the measures needed to augment the Consolidated Fund of a state to supplement the resources of the municipalities in the state on the basis of the recommendations made by the Finance Commission of the state. A. Since any other matter referred to the Commission by the President in the interests of sound finance. 4. The Commission shall determine their procedure and shall have such powers in the performance of their functions as Parliament may by law confer on them. 281. Recommendations of the Finance Commission. The President shall cause every recommendation made by the Finance Commission under the provisions of this Constitution together with an explanatory memorandum as to the action taken thereon to be laid before each House of Parliament. Miscellaneous Financial Provisions 282. Expenditure defrayable by the Union or a state out of its revenues. The Union or a state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which Parliament or the legislature of the state, as the case may be, may make laws. 283. Custody, etc., of consolidated funds, contingency funds and monies credited to the public accounts. 1. The custody of the Consolidated Fund of India and the Contingency Fund of India, the payment of monies into such funds, the withdrawal of monies therefrom, the custody of public monies other than those credited to such funds received by or on behalf of the Government of India, their payment into the public account of India and the withdrawal of monies from such account and all other matters connected with or ancillary to matters aforesaid shall be regulated by law made by Parliament, and, until a provision in that behalf is so made, shall be regulated by rules made by the President. 2. The custody of the consolidated fund of a state and the contingency fund of a state, the payment of monies into such funds, the withdrawal of monies therefrom, the custody of public monies other than those credited to such funds received by or on behalf of the government of the state, their payment into the public account of the state and the withdrawal of monies from such account and all other matters connected with or ancillary to matters aforesaid shall be regulated by law made by the legislature of the state, and, until a provision in that behalf is so made, shall be regulated by rules made by the governor of the state. 284. Custody of suitors' deposits and other monies received by public servants and courts. All monies received by or deposited with 1. Any officer employed in connection with the affairs of the Union or of a state in his capacity as such, other than revenues or public monies raised or received by the Government of India or the Government of the state, as the case may be, or 2. Any court within the territory of India to the credit of any cause, matter, account or persons, shall be paid into the public account of India or the public account of state, as the case may be. 285. Exemption of property of the Union from state taxation. 1. The property of the Union shall, save in so far as Parliament may by law otherwise provide, be exempt from all taxes imposed by a state or by any authority within a state. 2. Nothing in clause 1 shall, until Parliament by law otherwise provides, prevent any authority within a state from levying any tax on any property of the Union to which such property was immediately before the commencement of this Constitution liable or treated as liable, so long as that tax continues to be levied in that state. 286. Restrictions as to imposition of tax on the sale or purchase of goods. 1. No law of a state shall impose, or authorize the imposition of, a tax on the supply of goods or of services or both, where such supply takes place. A cents outside the state or a cents in the course of the import of the goods or services or both into, or export of the goods or services or both out of, the territory of India. 2. Parliament may by law formulate principles for determining when a sale or purchase of goods takes place in any of the ways mentioned in clause 1. 3. Omitted by the Constitution, 101st Amendment, Act, 2016, 287. Exemption from taxes on electricity. Save in so far as Parliament may by law otherwise provide, no law of a state shall impose, or authorize the imposition of, a tax on the consumption or sale of electricity, whether produced by a government or other persons, which is 1. Consumed by the Government of India, or sold to the Government of India for consumption by that government or 2. Consumed in the construction, maintenance or operation of any railway by the Government of India or a railway company operating that railway, or sold to that government or any such railway company for consumption in the construction, maintenance or operation of any railway. And any such law imposing, or authorizing the imposition of, a tax on the sale of electricity shall secure that the price of electricity sold to the Government of India for consumption by that government, or to any such railway company as aforesaid for consumption in the construction, maintenance or operation of any railway, shall be less by the amount of the tax than the price charged to other consumers of a substantial quantity of electricity. 288. Exemption from taxation by states in respect of water or electricity in certain cases. 1. Save in so far as the President may by order otherwise provide, no law of a state in force immediately before the commencement of this Constitution shall impose, or authorize the imposition of, a tax in respect of any water or electricity stored, generated, consumed, distributed or sold by any authority established by any existing law or any law made by Parliament for regulating or developing any interstate river or river valley. Explanation: the expression law of a state in force in this clause shall include a law of a state passed or made before the commencement of this Constitution and not previously repealed, notwithstanding that it or parts of it may not be then in operation, either at all or in particular areas. 2. The legislature of a state may by law impose, or authorize the imposition of, any such tax as is mentioned in clause 1, but no such law shall have any effect unless it has, after having been reserved for the consideration of the President, received his assent, and if any such law provides for the fixation of the rates and other incidents of such tax by means of rules or orders to be made under the law by any authority, the law shall provide for the previous consent of the President being obtained to the making of any such rule or order. 289. Exemption of property and income of a state from Union taxation. 1. The property and income of a state shall be exempt from Union taxation. 2. Nothing in clause 1 shall prevent the Union from imposing, or authorizing the imposition of, any tax to such extent, if any, as Parliament may by law provide in respect of a trade or business of any kind carried on by, or on behalf of, the government of a state, or any operations connected therewith, or any property used or occupied for the purposes of such trade or business, or any income accruing or arising in connection therewith. 3. Nothing in clause 2 shall apply to any trade or business, or to any class of trade or business, which Parliament may by law declare to be incidental to the ordinary functions of government. 290. Adjustment in respect of certain expenses and pensions. Where under the provisions of this Constitution the expenses of any court or commission, or the pension payable to or in respect of a person who has served before the commencement of this Constitution under the Crown in India or after such commencement in connection with the affairs of the Union or of a state, are charged on the Consolidated Fund of India or the Consolidated Fund of a state, then, if 1. In the case of a charge on the Consolidated Fund of India, the court or commission serves any of the separate needs of a state, or the person has served wholly or in part in connection with the affairs of a state, or 2. In the case of a charge on the Consolidated Fund of a state, the court or commission serves any of the separate needs of the Union or another state, or the person has served wholly or in part in connection with the affairs of the Union or another state. There shall be charged on and paid out of the Consolidated Fund of the state, or, as the case may be, the Consolidated Fund of India or the Consolidated Fund of the other state, such contribution in respect of the expenses or pension as may be agreed, or as may in default of agreement be determined by an arbitrator to be appointed by the Chief Justice of India. 290A. Annual payment to certain Devaswam funds a sum of 46,50,000 rupees shall be charged on, and paid out of the Consolidated Fund of the State of Kerala every year to the Travancore Devaswam Fund, and a sum of 13,50,000 rupees shall be charged on, and paid out of the Consolidated Fund of the State of Tamil Nadu, every year to the Devaswam Fund established in that state for the maintenance of Hindu temples and shrines in the territories transferred to that state on the first day of November, 1956, from the state of Travancore Cochin. 291. Privy Purse sums of rulers rep. By the Constitution, 26th Amendment, Act, 1971 S. 2. Chapter 2. Borrowing. 292. Borrowing by the Government of India. The executive power of the Union extends to borrowing upon the security of the Consolidated Fund of India within such limits, if any, as may from time to time be fixed by Parliament by law, and to the giving of guarantees within such limits, if any, as may be so fixed. 293. Borrowing by states. 1. Subject to the provisions of this article, the executive power of a state extends to borrowing within the territory of India upon the security of the consolidated fund of the state within such limits, if any, as may from time to time be fixed by the legislature of such state by law, and to the giving of guarantees within such limits, if any, as may be so fixed. 2. The Government of India may, subject to such conditions as may be laid down by or under any law made by Parliament, make loans to any state, or, so long as any limits fixed under Article 292 are not exceeded, give guarantees in respect of loans raised by any state, and any sums required for the purpose of making such loans shall be charged on the Consolidated Fund of India. 3. A state may not without the consent of the Government of India raise any loan if there is still outstanding any part of a loan which has been made to the state by the Government of India or by its predecessor government, or in respect of which a guarantee has been given by the Government of India or by its predecessor government. 4. A consent under Clause 3 may be granted subject to such conditions, if any, as the Government of India may think fit to impose. Chapter 3. Property, Contracts, Rights, Liabilities, Obligations and Suits. 294. Succession to property, assets, rights, liabilities and obligations in certain cases. As from the commencement of this Constitution. 1. All property and assets which immediately before such commencement were vested in His Majesty for the purposes of the government of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purposes of the government of each governor's province shall vest respectively in the Union and the corresponding state, and 2. All rights, liabilities and obligations of the government of the Dominion of India and of the government of each governor's province, whether arising out of any contract or otherwise, shall be the rights, liabilities and obligations respectively of the government of India and the government of each corresponding state, subject to any adjustment made or to be made by reason of the creation before the commencement of this Constitution of the Dominion of Pakistan or of the provinces of West Bengal, East Bengal, West Punjab and East Punjab. 295. Succession to property, assets, rights, liabilities and obligations in other cases. 1. As from the commencement of this Constitution. A sense all property and assets which immediately before such commencement were vested in any Indian state corresponding to a state specified in Part B of the first schedule shall vest in the Union, if the purposes for which such property and assets were held immediately before such commencement will thereafter be purposes of the Union relating to any of the matters enumerated in the Union list, and a sense all rights, liabilities and obligations of the government of any Indian state corresponding to a state specified in Part B of the first schedule, whether arising out of any contract or otherwise, shall be the rights, liabilities and obligations of the government of India. If the purposes for which such rights were acquired or liabilities or obligations were incurred before such commencement will thereafter be purposes of the Government of India relating to any of the matters enumerated in the Union list, subject to any agreement entered into in that behalf by the Government of India with the government of that state. 2. Subject as aforesaid, the government of each state specified in Part B of the first schedule shall, as from the commencement of this Constitution, be the successor of the government of the corresponding Indian state as regards all property and assets and all rights, liabilities and obligations, whether arising out of any contract or otherwise, other than those referred to in Clause 1. 296. Property accruing by escheat or lapse or as bona vacantia. Subject as hereinafter provided. Any property in the territory of India which, if this Constitution had not come into operation, would have accrued to His Majesty or, as the case may be, to the ruler of an Indian state by escheat or lapse, or as bona vacantia for want of a rightful owner, shall, if it is property situate in a state, vest in such state, and shall, in any other case, vest in the Union. Provided that any property which at the date when it would have so accrued to His Majesty or to the ruler of an Indian state was in the possession or under the control of the Government of India or the Government of a state shall, according as the purposes for which it was then used or held were purposes of the Union or of a state, vest in the Union or in that state. Explanation: in this article, the expressions rulers and Indian state have the same meanings as in Article 363. 297. Things of value within territorial waters or continental shelf and resources of the exclusive economic zone to vest in the Union. 1. All lands, minerals and other things of value underlying the ocean within the territorial waters, or the continental shelf, or the exclusive economic zone, of India shall vest in the Union and be held for the purposes of the Union. 2. All other resources of the exclusive economic zone of India shall also vest in the Union and be held for the purposes of the Union. 3. The limits of the territorial waters, the continental shelf, the exclusive economic zone, and other maritime zones, of India shall be such as may be specified, from time to time, by or under any law made by Parliament. 298. Power to carry on trade, etc. The executive power of the Union and of each state shall extend to the carrying on of any trade or business and to the acquisition, holding and disposal of property and the making of contracts for any purpose. Provided that 1. The said executive power of the Union shall, in so far as such trade or business or such purpose is not one with respect to which Parliament may make laws, be subject in each state to legislation by the state, and 2. The said executive power of each state shall, in so far as such trade or business or such purpose is not one with respect to which the state legislature may make laws, be subject to legislation by Parliament. 299. Contracts. 1. All contracts made in the exercise of the executive power of the Union or of a state shall be expressed to be made by the President, or by the Governor of the state, as the case may be, and all such contracts and all assurances of property made in the exercise of that power shall be executed on behalf of the President or the Governor by such persons and in such manner as he may direct or authorize. 2. Neither the President nor the Governor shall be personally liable in respect of any contract or assurance made or executed for the purposes of this Constitution, or for the purposes of any enactment relating to the Government of India heretofore in force, nor shall any person making or executing any such contract or assurance on behalf of any of them be personally liable in respect thereof. 300. Suits and proceedings. 1. The Government of India may sue or be sued by the name of the Union of India, and the Government of a state may sue or be sued by the name of the state, and may, subject to any provisions which may be made by Act of Parliament or of the legislature of such state enacted by virtue of powers conferred by this Constitution, sue or be sued in relation to their respective affairs in the like cases as the Dominion of India and the corresponding provinces or the corresponding Indian states might have sued or been sued if this Constitution had not been enacted. 2. If at the commencement of this Constitution A. Since any legal proceedings are pending to which the Dominion of India is a party, the Union of India shall be deemed to be substituted for the Dominion in those proceedings, and A. Since any legal proceedings are pending to which a province or an Indian state is a party, the corresponding state shall be deemed to be substituted for the province or the Indian state in those proceedings. Chapter 4. Right to Property. 300A. Persons not to be deprived of property save by authority of law. No person shall be deprived of his property save by authority of law. Part 13. Trade, Commerce and Intercourse within the Territory of India. 301. Freedom of trade, commerce and intercourse. Subject to the other provisions of this part, trade, commerce and intercourse throughout the Territory of India shall be free. 302. Power of Parliament to impose restrictions on trade, commerce and intercourse. Parliament may by law impose such restrictions on the freedom of trade, commerce or intercourse between one state and another or within any part of the territory of India as may be required in the public interest. 303. Restrictions on the legislative powers of the Union and of the states with regard to trade and commerce. 1. Notwithstanding anything in Article 302, neither Parliament nor the legislature of a state shall have power to make any law giving, or authorizing the giving of, any preference to one state over another, or making, or authorizing the making of, any discrimination between one state and another, by virtue of any entry relating to trade and commerce in any of the lists in the 7th Schedule. 2. Nothing in Clause 1 shall prevent Parliament from making any law giving, or authorizing the giving of, any preference or making, or authorizing the making of, any discrimination if it is declared by such law that it is necessary to do so for the purpose of dealing with a situation arising from scarcity of goods in any part of the territory of India. 304. Restrictions on trade, commerce and intercourse among states. Notwithstanding anything in Article 301 or Article 303, the legislature of a state may by law 1. Impose on goods imported from other states or the Union territories any tax to which similar goods manufactured or produced in that state are subject, so, however, as not to discriminate between goods so imported and goods so manufactured or produced, and 2. Impose such reasonable restrictions on the freedom of trade, commerce or intercourse with or within that state as may be required in the public interest. Provided that no bill or amendment for the purposes of Clause B shall be introduced or moved in the legislature of a state without the previous sanction of the President. 305. Saving of existing laws and laws providing for state monopolies. Nothing in Articles 301 and 303 shall affect the provisions of any existing law except in so far as the President may by order otherwise direct, and nothing in Article 301 shall affect the operation of any law made before the commencement of the Constitution, 4th Amendment, Act, 1955, in so far as it relates to, or prevent Parliament or the legislature of a state from making any law relating to, any such matter as is referred to in sub-clause 2, of Clause 6, of Article 19. 306. Power of certain states in Part B of the First Schedule to impose restrictions on trade and commerce. Rep. By the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. 307. Appointment of authority for carrying out the purposes of Articles 301 to 304. Parliament may by law appoint such authority as it considers appropriate for carrying out the purposes of Articles 301, 302, 303 and 304. And confer on the authority so appointed such powers and such duties as it thinks necessary. Part 14. Services under the Union and the States. Chapter 1. Services. 308. Interpretation in this part, unless the context otherwise requires. The expression state does not include the state of Jammu and Kashmir. 309. Recruitment and conditions of service of persons serving the Union or a state. Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state, provided that it shall be competent for the President or such person as he may direct in the case of services and posts in connection with the affairs of the Union, and for the Governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and the conditions of service of persons appointed to such services and posts until a provision in that behalf is made by or under an act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act. 310. Tenure of office of persons serving the Union or a state. 1. Except as expressly provided by this Constitution, every person who is a member of a defense service or of a civil service of the Union or of an All India service or holds any post connected with defense or any civil post under the Union holds office during the pleasure of the President, and every person who is a member of a civil service of a state or holds any civil post under a state holds office during the pleasure of the Governor of the state. 2. Notwithstanding that a person holding a civil post under the Union or a state holds office during the pleasure of the President or, as the case may be, of the Governor of the state, any contract under which a person, not being a member of a defense service or of an All India service or of a civil service of the Union or a state, is appointed under this Constitution to hold such a post may, if the President or the Governor, as the case may be, deems it necessary in order to secure the services of a person having special qualifications, provide for the payment to him of compensation, if before the expiration of an agreed period that post is abolished or he is, for reasons not connected with any misconduct on his part, required to vacate that post. 311. Dismissal, removal or reduction in rank of persons employed in civil capacities under the Union or a state. 1. No person who is a member of a civil service of the Union or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. 2. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Provided that where it is proposed after such inquiry, to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Provided further that this clause shall not apply. A sense where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or a sense where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason, to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry, or a sense where the President or the Governor, as the case may be, is satisfied that in the interest of the security of the state it is not expedient to hold such inquiry. 3. If, in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in Clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. 312. All India Services. 1. Notwithstanding anything in Chapter 6 of Part 6 or Part 11, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting that it is necessary or expedient in the national interest so to do, Parliament may by law provide for the creation of one or more All India services, including an All India Judicial Service, common to the Union and the States, and, subject to the other provisions of this chapter, regulate the recruitment and the conditions of service of persons appointed to any such service. 2. The services known at the commencement of this Constitution as the Indian Administrative Service and the Indian Police Service shall be deemed to be services created by Parliament under this article. 3. The All India Judicial Service referred to in Clause 1 shall not include any post inferior to that of a district judge as defined in Article 236. 4. The law providing for the creation of the All India Judicial Service aforesaid may contain such provisions for the amendment of Chapter 6 of Part 6 as may be necessary for giving effect to the provisions of that law, and no such law shall be deemed to be an amendment of this Constitution for the purposes of Article 368. 312a. Power of Parliament to vary or revoke conditions of service of officers of certain services. 1. Parliament may by law a sense vary or revoke, whether prospectively or retrospectively, the conditions of service as respects remuneration, leave and pension, and the rights as respects disciplinary matters of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this Constitution, continue on and after the commencement of the Constitution, 28th Amendment, Act, 1972, to serve under the Government of India or of a state in any service or post. A sense vary or revoke, whether prospectively or retrospectively, the conditions of service as respects pension of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this Constitution, retired or otherwise cease to be in service at any time before the commencement of the Constitution, 28th Amendment, Act, 1972. Provided that in the case of any such person who is holding or has held the office of the Chief Justice or other Judge of the Supreme Court or a High Court, the Controller and Auditor General of India, the Chairman or other member of the Union or a State Public Service Commission or the Chief Election Commissioner, nothing in Subclause A, or Subclause B, shall be construed as empowering Parliament to vary or revoke, after his appointment to such post, the conditions of his service to his disadvantage, except in so far as such conditions of service are applicable to him by reason of his being a person appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India. 2. Except to the extent provided for by Parliament by law under this article, nothing in this article shall affect the power of any legislature or other authority under any other provision of this Constitution to regulate the conditions of service of persons referred to in Clause 1. 3. Neither the Supreme Court nor any other court shall have jurisdiction in a sense any dispute arising out of any provision of, or any endorsement on, any covenant, agreement or other similar instrument which was entered into or executed by any person referred to in Clause 1, or arising out of any letter issued to such person, in relation to his appointment to any civil service of the Crown in India or his continuance in service under the government of the Dominion of India or a province thereof. A sense any dispute in respect of any right, liability or obligation under Article 314 as originally enacted. 4. The provisions of this article shall have effect notwithstanding anything in Article 314 as originally enacted or in any other provision of this Constitution. 313. Transitional provisions until other provision is made in this behalf under this Constitution. All the laws in force immediately before the commencement of this Constitution and applicable to any public service or any post which continues to exist after the commencement of this Constitution, as an All India service or as service or post under the Union or a state shall continue in force so far as consistent with the provisions of this Constitution. 314. Provision for protection of existing officers of certain services Rep. By the Constitution, 28th Amendment, Act, 1972, S. 3, WEF the 29th of August 1972. Chapter 2. Public Service Commissions 315. Public Service Commissions for the Union and for the States 1. Subject to the provisions of this article, there shall be a Public Service Commission for the Union and a Public Service Commission for each state. 2. Two or more states may agree that there shall be one Public Service Commission for that group of states, and if a resolution to that effect is passed by the House or, where there are 2 houses, by each house of the legislature of each of those states, Parliament may by law provide for the appointment of a Joint State Public Service Commission, referred to in this chapter as Joint Commission, to serve the needs of those states. 3. Any such law as aforesaid may contain such incidental and consequential provisions as may be necessary or desirable for giving effect to the purposes of the law. 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may, with the approval of the President, agree to serve all or any of the needs of the state. 5. References in this Constitution to the Union Public Service Commission or a State Public Service Commission shall, unless the context otherwise requires, be construed as references to the Commission serving the needs of the Union or, as the case may be, the state as respects the particular matter in question. 316. Appointment and term of office of members. 1. The chairman and other members of a Public Service Commission shall be appointed, in the case of the Union Commission or a Joint Commission, by the President, and in the case of a State Commission, by the Governor of the State. Provided that as nearly as may be 1/2 of the members of every Public Service Commission shall be persons who at the dates of their respective appointments have held office for at least 10 years either under the Government of India or under the Government of a State, and in computing the said period of 10 years any period before the commencement of this Constitution during which a person has held office under the Crown in India or under the Government of an Indian state shall be included. 2. If the office of the chairman of the Commission becomes vacant or if any such chairman is by reason of absence or for any other reason unable to perform the duties of his office, those duties shall, until some person appointed under Clause 1, to the vacant office has entered on the duties thereof or, as the case may be, until the chairman has resumed his duties, be performed by such one of the other members of the Commission as the President, in the case of the Union Commission or a Joint Commission, and the Governor of the State in the case of a State Commission, may appoint for the purpose. 3. A member of a Public Service Commission shall hold office for a term of 6 years from the date on which he enters upon his office or until he attains, in the case of the Union Commission, the age of 65 years, and in the case of a State Commission or a Joint Commission, the age of 62 years, whichever is earlier. Provided that a member of a Public Service Commission may, by writing under his hand addressed, in the case of the Union Commission or a Joint Commission, to the President, and in the case of a State Commission, to the Governor of the State, resign his office. A member of a Public Service Commission may be removed from his office in the manner provided in Clause 1, or Clause 3, of Article 317. 4. A person who holds office as a member of a Public Service Commission shall, on the expiration of his term of office, be ineligible for reappointment to that office. 317. Removal and suspension of a member of a Public Service Commission. 1. Subject to the provisions of Clause 3, the chairman or any other member of a Public Service Commission shall only be removed from his office by order of the President on the ground of misbehavior after the Supreme Court, on reference being made to it by the President, has, on inquiry held in accordance with the procedure prescribed in that behalf under Article 145, reported that the chairman or such other member, as the case may be, ought on any such ground to be removed. 2. The President, in the case of the Union Commission or a Joint Commission, and the Governor in the case of a State Commission, may suspend from office the chairman or any other member of the Commission in respect of whom reference has been made to the Supreme Court under Clause 1, until the President has passed orders on receipt of the report of the Supreme Court on such reference. 3. Notwithstanding anything in Clause 1, the President may by order remove from office the chairman or any other member of a Public Service Commission if the chairman or such other member, as the case may be, is adjudged an insolvent or A cents engages during his term of office in any paid employment outside the duties of his office, or a cents is, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body. 4. If the chairman or any other member of a public service commission is or becomes in any way concerned or interested in any contract or agreement made by or on behalf of the Government of India or the Government of a state, or participates in any way in the profit thereof or in any benefit or emolument arising therefrom otherwise than as a member and in common with the other members of an incorporated company, he shall, for the purposes of clause 1, be deemed to be guilty of misbehavior. 318. Power to make regulations as to conditions of service of members and staff of the Commission. In the case of the Union Commission or a joint commission, the President and, in the case of a state commission, the Governor of the state may by regulations 1. Determine the number of members of the Commission and their conditions of service, and 2. Make provision with respect to the number of members of the staff of the Commission and their conditions of service. Provided that the conditions of service of a member of a public service commission shall not be varied to his disadvantage after his appointment. 319. Prohibition as to the holding of offices by members of commission on ceasing to be such members. On ceasing to hold office. 1. The chairman of the Union Public Service Commission shall be ineligible for further employment either under the Government of India or under the Government of a state. 2. The chairman of a state public service commission shall be eligible for appointment as the chairman or any other member of the Union Public Service Commission or as the chairman of any other state public service commission, but not for any other employment either under the Government of India or under the Government of a state. 3. A member other than the chairman of the Union Public Service Commission shall be eligible for appointment as the chairman of the Union Public Service Commission or as the chairman of a state public service commission, but not for any other employment either under the Government of India or under the Government of a state. 4. A member other than the chairman of a state public service commission shall be eligible for appointment as the chairman or any other member of the Union Public Service Commission or as the chairman of that or any other state public service commission, but not for any other employment either under the Government of India or under the Government of a state. 320. Functions of Public Service Commissions. 1. It shall be the duty of the Union and the State Public Service Commissions to conduct examinations for appointment to the services of the Union and the services of the State respectively. 2. It shall also be the duty of the Union Public Service Commission, if requested by any two or more states so to do, to assist those states in framing and operating schemes of joint recruitment for any services for which candidates possessing special qualifications are required. 3. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted a-cents on all matters relating to methods of recruitment to civil services and for civil posts. A-cents on the principles to be followed in making appointments to civil services and posts and in making promotions and transfers from one service to another and on the suitability of candidates for such appointments, promotions or transfers. A-cents on all disciplinary matters affecting a person serving under the Government of India or the Government of a state in a civil capacity, including memorials or petitions relating to such matters. A-cents on any claim by or in respect of a person who is serving or has served under the Government of India or the Government of a state or under the Crown in India or under the Government of an Indian state, in a civil capacity. That any costs incurred by him in defending legal proceedings instituted against him in respect of acts done or purporting to be done in the execution of his duties should be paid out of the Consolidated Fund of India, or, as the case may be, out of the Consolidated Fund of the State. a cents on any claim for the award of a pension in respect of injuries sustained by a person while serving under the Government of India or the Government of a state or under the Crown in India or under the Government of an Indian state, in a civil capacity, and any question as to the amount of any such award. And it shall be the duty of a Public Service Commission to advise on any matter so referred to them and on any other matter which the President, or, as the case may be, the Governor of the State, may refer to them. Provided that the President as respects the All India services and also as respects other services and posts in connection with the affairs of the Union, and the Governor, as respects other services and posts in connection with the affairs of a state, may make regulations specifying the matters in which either generally, or in any particular class of case or in any particular circumstances, it shall not be necessary for a Public Service Commission to be consulted. 4. Nothing in Clause 3 shall require a Public Service Commission to be consulted as respects the manner in which any provision referred to in Clause 4 of Article the 16th of may be made or as respects the manner in which effect may be given to the provisions of Article 335. 5. All regulations made under the proviso to Clause 3 by the President or the Governor of a state shall be laid for not less than 14 days before each House of Parliament or the House or each House of the Legislature of the state, as the case may be, as soon as possible after they are made, and shall be subject to such modifications, whether by way of repeal or amendment, as both Houses of Parliament or the House or both Houses of the Legislature of the state may make during the session in which they are so laid. 321. Power to extend functions of Public Service Commissions. An act made by Parliament or, as the case may be, the legislature of a state may provide for the exercise of additional functions by the Union Public Service Commission or the State Public Service Commission as respects the services of the Union or the state and also as respects the services of any local authority or other body corporate constituted by law or of any public institution. 322. Expenses of Public Service Commissions. The expenses of the Union or a State Public Service Commission, including any salaries, allowances and pensions payable to or in respect of the members or staff of the Commission, shall be charged on the Consolidated Fund of India or, as the case may be, the Consolidated Fund of the State. 323. Reports of Public Service Commissions. 1. It shall be the duty of the Union Commission to present annually to the President a report as to the work done by the Commission, and on receipt of such report the President shall cause a copy thereof together with a memorandum explaining, as respects the cases, if any, where the advice of the Commission was not accepted, the reasons for such non-acceptance to be laid before each House of Parliament. 2. It shall be the duty of a State Commission to present annually to the Governor of the State a report as to the work done by the Commission, and it shall be the duty of a Joint Commission to present annually to the Governor of each of the States the needs of which are served by the Joint Commission a report as to the work done by the Commission in relation to that State, and in either case the Governor shall, on receipt of such a report, cause a copy thereof together with a memorandum explaining, as respects the cases, if any, where the advice of the Commission was not accepted, the reasons for such non-acceptance to be laid before the legislature of the state. Part Xiva. Tribunals. 323a. Administrative Tribunals. 1. Parliament may, by law, provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state or of any local or other authority within the territory of India or under the control of the Government of India or of any corporation owned or controlled by the Government. 2. A law made under Clause 1 may a sense provide for the establishment of an administrative tribunal for the Union and a separate administrative tribunal for each state or for two or more states. I. Specify the jurisdiction, powers, including the power to punish for contempt, and authority which may be exercised by each of the said tribunals. A. Provide for the procedure, including provisions as to limitation and rules of evidence, to be followed by the said tribunals. I. Exclude the jurisdiction of all courts, except the jurisdiction of the Supreme Court under Article 136. With respect to the disputes or complaints referred to in Clause 1. A. Provide for the transfer to each such administrative tribunal of any cases pending before any court or other authority immediately before the establishment of such tribunal as would have been within the jurisdiction of such tribunal if the causes of action on which such suits or proceedings are based had arisen after such establishment. I. Repeal or amend any order made by the President under Clause 3 of Article 371d. A. Contain such supplemental, incidental and consequential provisions, including provisions as to fees, as Parliament may deem necessary for the effective functioning of, and for the speedy disposal of cases by, and the enforcement of the orders of, such tribunals. 3. The provisions of this article shall have effect notwithstanding anything in any other provision of this Constitution or in any other law for the time being in force. 323b. Tribunals for other matters. 1. The appropriate legislature may, by law, provide for the adjudication or trial by tribunals of any disputes, complaints, or offences with respect to all or any of the matters specified in Clause 2, with respect to which such legislature has power to make Clause 2. The matters referred to in Clause 1 are the following, namely: A. Levy, assessment, collection and enforcement of any tax. I. Foreign exchange, import and export across customs frontiers. A. Industrial and labor disputes. A. Land reforms by way of acquisition by the state of any estate as defined in Article 31A or of any rights therein or the extinguishment or modification of any such rights or by way of sealing on agricultural land or in any other way. A. Sealing on urban property. A. Elections to either House of Parliament or the House or either House of the Legislature of a state, but excluding the matters referred to in Article 329 and Article 329a. A. Production, procurement, supply and distribution of foodstuffs, including edible oil seeds and oils, and such other goods as the President may, by public notification, declare to be essential goods for the purpose of this article and control of prices of such goods. A. Rent. Its regulation and control and tenancy issues including the right, title and interest of landlords and tenants. A. Offences against laws with respect to any of the matters specified in subclauses A, 2, H, and fees in respect of any of those matters. A. Any matter incidental to any of the matters specified in subclauses A, 2, I. 3. A law made under Clause 1 may. A. Provide for the establishment of a hierarchy of tribunals. I. Specify the jurisdiction, powers, including the power to punish for contempt, and authority which may be exercised by each of the said tribunals. A. Provide for the procedure, including provisions as to limitation and rules of evidence, to be followed by the said tribunals. I. Exclude the jurisdiction of all courts, except the jurisdiction of the Supreme Court under Article 136, with respect to all or any of the matters falling within the jurisdiction of the said tribunals. A. Provide for the transfer to each such tribunal of any cases pending before any court or any other authority immediately before the establishment of such tribunal as would have been within the jurisdiction of such tribunal if the causes of action on which such suits or proceedings are based had arisen after such establishment. A. Contain such supplemental, incidental and consequential provisions, including provisions as to fees, as the appropriate legislature may deem necessary for the effective functioning of, and for the speedy disposal of cases by, and the enforcement of the orders of, such tribunals. 4. The provisions of this article shall have effect notwithstanding anything in any other provision of this Constitution or in any other law for the time being in force. Explanation in this article, appropriate legislature, in relation to any matter, means Parliament or, as the case may be, a state legislature competent to make laws with respect to such matter in accordance with the provisions of Part 11. Part 15. Elections 324. Superintendence, direction and control of elections to be vested in an election commission. 1. The superintendence, direction and control of the preparation of the electoral rolls for, and the conduct of, all elections to Parliament and to the legislature of every state and of elections to the offices of President and Vice President held under this Constitution shall be vested in a commission, referred to in this Constitution as the Election Commission. 2. The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix, and the appointment of the Chief Election Commissioner and other election commissioners shall, subject to the provisions of any law made in that behalf by Parliament, be made by the President. 3. When any other election commissioner is so appointed, the Chief Election Commissioner shall act as the chairman of the Election Commission. 4. Before each general election to the House of the People and to the Legislative Assembly of each state, and before the first general election and thereafter before each biennial election to the Legislative Council of each state having such council, the President may also appoint after consultation with the Election Commission such regional commissioners as he may consider necessary to assist the Election Commission in the performance of the functions conferred on the Commission by Clause 1. 5. Subject to the provisions of any law made by Parliament, the conditions of service and tenure of office of the election commissioners and the regional commissioners shall be such as the President may by rule determine. Provided that the Chief Election Commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court, and the conditions of service of the Chief Election Commissioner shall not be varied to his disadvantage after his appointment. Provided further that any other election commissioner or a regional commissioner shall not be removed from office except on the recommendation of the Chief Election Commissioner. 6. The President, or the Governor of a state, shall, when so requested by the Election Commission, make available to the Election Commission or to a regional commissioner such staff as may be necessary for the discharge of the functions conferred on the Election Commission by Clause 1. 325. No person to be ineligible for inclusion in, or to claim to be included in a special, electoral roll on grounds of religion, race, caste or sex. There shall be one general electoral roll for every territorial constituency for election to either House of Parliament or to the House or either House of the Legislature of a state, and no person shall be ineligible for inclusion in any such roll or claim to be included in any special electoral roll for any such constituency on grounds only of religion, race, caste, sex or any of them. 326. Elections to the House of the People and to the Legislative Assemblies of States to be on the basis of adult suffrage. The elections to the House of the People and to the Legislative Assembly of every state shall be on the basis of adult suffrage, that is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf by or under any law made by the appropriate legislature, and is not otherwise disqualified under this Constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled to be registered as a voter at any such election. 327. Power of Parliament to make provision with respect to elections to legislatures. Subject to the provisions of this Constitution, Parliament may from time to time by law make provision with respect to all matters relating to, or in connection with, Elections to either House of Parliament or to the House or either House of the Legislature of a state, including the preparation of electoral rolls, the delimitation of constituencies and all other matters necessary for securing the due constitution of such House or Houses. 328. Power of legislature of a state to make provision with respect to elections to such legislature subject to the provisions of this Constitution, and in so far as provision in that behalf is not made by Parliament, the legislature of a state may from time to time by law make provision with respect to all matters relating to, or in connection with, the elections to the House or either House of the Legislature of the state, including the preparation of electoral rolls and all other matters necessary for securing the due constitution of such House or Houses. 329. Bar to interference by courts in electoral matters. Notwithstanding anything in this Constitution. 1. The validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies, made or purporting to be made under Article 327 or Article 328, shall not be called in question in any court. 2. No election to either House of Parliament or to the House or either House of the Legislature of a state shall be called in question except by an election petition presented to such authority and in such manner as may be provided for by or under any law made by the appropriate legislature. 329a. Special provision as to elections to Parliament in the case of Prime Minister and Speaker Rep. By the Constitution. 44th Amendment, Act, 1978, S. 36, WEF the 20th of June 1979. Part 16. Special provisions relating to certain classes. 330. Reservation of seats for scheduled castes and scheduled tribes in the House of the People. 1. Seats shall be reserved in the House of the People for A cents the scheduled castes, A cents the scheduled tribes except the scheduled tribes in the autonomous districts of Assam, and A cents the scheduled tribes in the autonomous districts of Assam. 2. The number of seats reserved in any state or union territory for the scheduled castes or the scheduled tribes under Clause 1, shall bear, as nearly as may be, the same proportion to the total number of seats allotted to that state or union territory in the House of the People as the population of the scheduled castes in the state or union territory or of the scheduled tribes in the state or union territory or part of the state or union territory, as the case may be, in respect of which seats are so reserved, bears to the total population of the state or union territory. 3. Notwithstanding anything contained in Clause 2, the number of seats reserved in the House of the People for the scheduled tribes in the autonomous districts of Assam shall bear to the total number of seats allotted to that state a proportion not less than the population of the scheduled tribes in the said autonomous districts bears to the total population of the state. Explanation. In this article and in Article 332, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. Provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published, be construed as a reference to the 2001 census. 331. Representation of the Anglo-Indian community in the House of the People. Notwithstanding anything in Article 81, the President may, if he is of opinion that the Anglo-Indian community is not adequately represented in the House of the People, nominate not more than 2 members of that community to the House of the People. 332. Reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states. 1. Seats shall be reserved for the scheduled castes and the scheduled tribes, except the scheduled tribes in the autonomous districts of Assam, in the legislative assembly of every state. 2. Seats shall be reserved also for the autonomous districts in the legislative assembly of the state of Assam. 3. The number of seats reserved for the scheduled castes or the scheduled tribes in the Legislative Assembly of any state under Clause 1, shall bear, as nearly as may be, the same proportion to the total number of seats in the Assembly as the population of the scheduled castes in the state or of the scheduled tribes in the state or part of the state, as the case may be, in respect of which seats are so reserved, bears to the total population of the state. 4. Notwithstanding anything contained in Clause 3, until the taking effect, under Article 170, of the readjustment, on the basis of the first census after the year 2026, of the number of seats in the legislative assemblies of the states of Arunachal Pradesh, Meghalaya, Mizoram and Nagaland, the seats which shall be reserved for the scheduled tribes in the legislative assembly of any such state shall be, I cents if all the seats in the legislative assembly of such state in existence on the date of coming into force of the Constitution, 57th Amendment, Act, 1987, hereafter in this clause referred to as the existing assembly, are held by member of the scheduled tribes, all the seats except 1. A cents in any other case, such number of seats as bears to the total number of seats, a proportion not less than the number, as on the said date, of members belonging to the scheduled tribes in the existing assembly bears to the total number of seats in the existing assembly. 5. Notwithstanding anything contained in Clause 3, until the readjustment, under Article 170, takes effect on the basis of the first census after the year 320.1, of the number of seats in the Legislative Assembly of the State of Tripura, the seats which shall be reserved for the scheduled tribes in the Legislative Assembly shall be, such number of seats as bears to the total number of seats, a proportion not less than the number, as on the date of coming into force of the Constitution, 72nd Amendment, Act, 1992, of members belonging to the scheduled tribes in the Legislative Assembly in existence on the said date bears to the total number of seats in that assembly. 6. The number of seats reserved for an autonomous district in the Legislative Assembly of the State of Assam shall bear to the total number of seats in that assembly a proportion not less than the population of the district bears to the total population of the state. 7. The constituencies for the seats reserved for any autonomous district of Assam shall not comprise any area outside that district. 8. No person who is not a member of a scheduled tribe of any autonomous district of the state of Assam shall be eligible for election to the Legislative Assembly of the state from any constituency of that district. Provided that for elections to the Legislative Assembly of the State of Assam, the representation of the scheduled tribes and non-scheduled tribes in the constituencies included in the Bodoland Territorial Areas District, so notified, and existing prior to the constitution of the Bodoland Territorial Areas District, shall be maintained. 333. Representation of the Anglo-Indian community in the legislative assemblies of the states. Notwithstanding anything in Article 170, the governor of a state may, if he is of opinion that the Anglo-Indian community needs representation in the legislative assembly of the state and is not adequately represented therein, nominate one member of that community to the assembly. 334. Reservation of seats and special representation to cease after 70 years. Notwithstanding anything in the foregoing provisions of this part, the provisions of this Constitution relating to 1. The reservation of seats for the scheduled castes and the scheduled tribes in the House of the People and in the legislative assemblies of the states, and 2. The representation of the Anglo-Indian community in the House of the People and in the legislative assemblies of the states by nomination, shall cease to have effect on the expiration of a period of 70 years from the commencement of this Constitution. Provided that nothing in this article shall affect any representation in the House of the People or in the Legislative Assembly of a state until the dissolution of the then existing House or Assembly, as the case may be. 335. claims of scheduled castes and scheduled tribes to services and posts. The claims of the members of the scheduled castes and the scheduled tribes shall be taken into consideration, consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts in connection with the affairs of the Union or of a state. Provided that nothing in this article shall prevent in making of any provision in favor of the members of the scheduled castes and the scheduled tribes for relaxation in qualifying marks in any examination or lowering the standards of evaluation, for reservation in matters of promotion to any class or classes of services or posts in connection with the affairs of the Union or of a state. 336. Special provision for Anglo-Indian community in certain services. 1. During the first 2 years after the commencement of this Constitution, appointments of members of the Anglo-Indian community to posts in the railway, customs, postal and telegraph services of the Union shall be made on the same basis as immediately before the 15th day of August, 1947. During every succeeding period of 2 years, the number of posts reserved for the members of the said community in the said services shall, as nearly as possible, be less by 10% than the numbers so reserved during the immediately preceding period of 2 years. Provided that at the end of 10 years from the commencement of this Constitution all such reservations shall cease. 2. Nothing in Clause 1 shall bar the appointment of members of the Anglo-Indian community to posts other than, or in addition to, those reserved for the community under that clause if such members are found qualified for appointment on merit as compared with the members of other communities. 337. Special provision with respect to educational grants for the benefit of Anglo-Indian community during the first 3 financial years after the commencement of this Constitution. The same grants, if any, shall be made by the Union and by each state for the benefit of the Anglo-Indian community in respect of education as were made in the financial year ending on the 31st day of March, 1948. During every succeeding period of 3 years the grants may be less by 10% than those for the immediately preceding period of 3 years. Provided that at the end of 10 years from the commencement of this Constitution such grants, to the extent to which they are a special concession to the Anglo-Indian community, shall cease. Provided further that no educational institution shall be entitled to receive any grant under this article unless at least 40% of the annual admissions therein are made available to members of communities other than the Anglo-Indian community. 338. National Commission for Scheduled Castes. 1. There shall be a commission for the scheduled castes to be known as the National Commission for the Scheduled Castes. 2. Subject to the provisions of any law made in this behalf by Parliament, the Commission shall consist of a chairperson, vice-chairperson and 3 other members, and the conditions of service and tenure of office of the chairperson, vice-chairperson and other members so appointed shall be such as the President may by rule determine. 3. The chairperson, vice-chairperson and other members of the Commission shall be appointed by the President by warrant under his hand and seal. 4. The Commission shall have the power to regulate its own procedure. 5. It shall be the duty of the Commission a. To investigate and monitor all matters relating to the safeguards provided for the scheduled castes under this Constitution or under any other law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. A. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes. A. To participate and advise on the planning process of socio-economic development of the scheduled castes and to evaluate the progress of their development under the Union and any state. I. To present to the President, annually and at such other times as the Commission may deem fit, reports upon the working of those safeguards. A. To make in such reports recommendations as to the measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection welfare and socio-economic development of the scheduled castes and assents to discharge such other functions in relation to the protection, welfare and development and advancement of the scheduled castes as the President may, subject to the provisions of any law made by Parliament, by rule specify. 6. The President shall cause all such reports to be laid before each House of Parliament along with a memorandum explaining the action taken or proposed to be taken on the recommendations relating to the Union and the reasons for the non-acceptance, if any, of such recommendations. 7. Where any such report, or any part thereof, relates to any matter with which any state government is concerned, a copy of such report shall be forwarded to the governor of the state who shall cause it to be laid before the legislature of the state along with a memorandum explaining the action taken or proposed to be taken on the recommendations relating to the state and the reasons for the non-acceptance, if any, of such recommendations. 8. The Commission shall, while investigating any matter referred to in sub-clause A, or inquiring into any complaint referred to in sub-clause B, of clause 5, have all the powers of a civil court trying a suit and in particular in respect of the following matters, namely: I. Summoning and enforcing the attendance of any person from any part of India and examining him on oath. A. Requiring the discovery and production of any document. A. Receiving evidence on affidavits. A. Requisitioning any public record or copy thereof from any court or office. A. Issuing commissions for the examination of witnesses and documents. A. Any other matter which the President may, by rule, determine. 9. The Union and every state government shall consult the Commission on all major policy matters affecting scheduled castes. 10. In this article, references to the scheduled castes shall be construed as including references to such other backward classes as the President may, on receipt of the report of a commission appointed under Clause 1 of Article 340, by order specify, and also to the Anglo-Indian community. 338a. National Commission for Scheduled Tribes 1. There shall be a commission for the scheduled tribes to be known as the National Commission for the Scheduled Tribes. 2. Subject to the provisions of any law made in this behalf by Parliament, the commission shall consist of a chairperson, vice-chairperson and 3 other members, and the conditions of service and tenure of office of the chairperson, vice-chairperson and other members so appointed shall be such as the President may by rule determine. 3. The chairperson, vice-chairperson and other members of the Commission shall be appointed by the President by warrant under his hand and seal. 4. The Commission shall have the power to regulate its own procedure. 5. It shall be the duty of the Commission A. To investigate and monitor all matters relating to the safeguards provided for the scheduled tribes under this Constitution or under any other law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. A. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled tribes. A. To participate and advise on the planning process of socio-economic development of the scheduled tribes and to evaluate the progress of their development under the Union and any state. I. To present to the President, annually and at such other times as the Commission may deem fit, reports upon the working of those safeguards. A. To make in such reports recommendations as to the measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection, welfare and socio-economic development of the scheduled tribes, and A. To discharge such other functions in relation to the protection, welfare and development and advancement of the scheduled tribes as the President may, subject to the provisions of any law made by Parliament, by rule specify. 6. The President shall cause all such reports to be laid before each House of Parliament along with a memorandum explaining the action taken or proposed to be taken on the recommendations relating to the Union and the reasons for the non-acceptance, if any, of any of such recommendations. 7. Where any such report, or any part thereof, relates to any matter with which any state government is concerned, a copy of such report shall be forwarded to the governor of the state, who shall cause it to be laid before the legislature of the state, along with a memorandum explaining the action taken or proposed to be taken on the recommendations relating to the state and the reasons for the non-acceptance, if any, of any of such recommendations. 8. The Commission shall, while investigating any matter referred to in subclause A, or inquiring into any complaint referred to in subclause B, of clause 5, have all the powers of a civil court trying a suit, and in particular in respect of the following matters, namely: I. Summoning and enforcing the attendance of any person from any part of India and examining him on oath. A. Requiring the discovery and production of any document. A. Receiving evidence on affidavits. A. Requisitioning any public record or copy thereof from any court or office. A. Issuing commissions for the examination of witnesses and documents. A. Any other matter which the President may, by a rule, determine. 9. The Union and every state government shall consult the Commission on all major policy matters affecting scheduled tribes. 339. Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes. 1. The President may at any time and shall, at the expiration of 10 years from the commencement of this Constitution, by order appoint a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the states. The order may define the composition, powers and procedure of the commission, and may contain such incidental or ancillary provisions as the President may consider necessary or desirable. 2. The executive power of the Union shall extend to the giving of directions to a state as to the drawing up and execution of schemes specified in a direction to be essential for the welfare of the scheduled tribes in the state. 340. Appointment of a commission to investigate the conditions of backward classes. 1. The President may by order appoint a commission consisting of such persons as he thinks fit to investigate the conditions of socially and educationally backward classes within the territory of India and the difficulties under which they labor, and to make recommendations as to the steps that should be taken by the Union or any state to remove such difficulties and to improve their condition, and as to the grants that should be made for the purpose by the Union or any state and the conditions subject to which such grants should be made. And the order appointing such commission shall define the procedure to be followed by the commission. 2. A commission so appointed shall investigate the matters referred to them and present to the President to report, setting out the facts as found by them and making such recommendations as they think proper. 3. The President shall cause a copy of the report so presented together with a memorandum explaining the action taken thereon to be laid before each House of Parliament. 341. Scheduled castes. 1. The President may, with respect to any state or Union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the castes, races or tribes or parts of or groups within castes, races or tribes which shall for the purposes of this Constitution be deemed to be scheduled castes in relation to that state or Union territory, as the case may be. 2. Parliament may by law include in or exclude from the list of scheduled castes specified in a notification issued under Clause 1, any caste, race or tribe or part of or group within any caste, race or tribe, but save as aforesaid a notification issued under the said clause shall not be varied by any subsequent notification. 342. Scheduled tribes. 1. The President may, with respect to any state or Union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the tribes or tribal communities or parts of or groups within tribes or tribal communities which shall for the purposes of this Constitution be deemed to be scheduled tribes in relation to that state or Union territory, as the case may be. 2. Parliament may by law include in or exclude from the list of scheduled tribes specified in a notification issued under Clause 1, any tribe or tribal community or part of or group within any tribe or tribal community, but save as aforesaid a notification issued under the said clause shall not be varied by any subsequent notification. Part 17. Official Language Chapter 1. Language of the Union 343. Official Language of the Union 1. The official language of the Union shall be Hindi in Devanagari script. The form of numerals to be used for the official purposes of the Union shall be the international form of Indian numerals. 2. Notwithstanding anything in Clause 1, for a period of 15 years from the commencement of this Constitution, the English language shall continue to be used for all the official purposes of the Union for which it was being used immediately before such commencement, provided that the President may, during the said period, by order authorize the use of the Hindi language in addition to the English language and of the Devanagari form of numerals in addition to the international form of Indian numerals for any of the official purposes of the Union. 3. Notwithstanding anything in this article, Parliament may by law provide for the use, after the said period of 15 years, of a sense the English language, or a sense the Devanagari form of numerals, for such purposes as may be specified in the law. 344. Commission and Committee or Parliament on Official Language 1. The President shall, at the expiration of 5 years from the commencement of this Constitution and thereafter at the expiration of 10 years from such commencement, by order constitute a commission which shall consist of a chairman and such other members representing the different languages specified in the 8th schedule as the President may appoint, and the order shall define the procedure to be followed by the commission. 2. It shall be the duty of the Commission to make recommendations to the President as to assents the progressive use of the Hindi language for the official purposes of the Union, a sense restrictions on the use of the English language for all or any of the official purposes of the Union, a sense the language to be used for all or any of the purposes mentioned in Article 348, a sense the form of numerals to be used for any one or more specified purposes of the Union, a sense any other matter referred to the Commission by the President as regards the official language of the Union and the language for communication between the Union and a state or between one state and another and their use. 3. In making their recommendations under Clause 2, the Commission shall have due regard to the industrial, cultural and scientific advancement of India, and the just claims and the interests of persons belonging to the non-Hindi speaking areas in regard to the public services. 4. There shall be constituted a committee consisting of 30 members, of whom 20 shall be members of the House of the People and 10 shall be members of the Council of States to be elected respectively by the members of the House of the People and the members of the Council of States in accordance with the system of proportional representation by means of the single transferable vote. 5. It shall be the duty of the committee to examine the recommendations of the Commission constituted under Clause 1, and to report to the President their opinion thereon. 6. Notwithstanding anything in Article 343, the President may, after consideration of the report referred to in Clause 5, issue directions in accordance with the whole or any part of that report. Chapter 2. Regional Languages 345. Official language or languages of a state. Subject to the provisions of Articles 346 and 347, the legislature of a state may by law adopt any one or more of the languages in use in the state or Hindi as the language or languages to be used for all or any of the official purposes of that state. Provided that, until the legislature of the state otherwise provides by law, the English language shall continue to be used for those official purposes within the state for which it was being used immediately before the commencement of this Constitution.